This AI-generated podcast is for general information only and does not constitute financial or legal advice. Please consult a qualified professional. Welcome to the Luxembourg Fundcast. Produced by Bertrand Mariaux, a regulatory lawyer qualified as Avocat à la Cour in Luxembourg and Paris, this show brings you reliable insights on Luxembourg regulations sourced from curated official references. This episode is current as of 21 May 2026.
Right, so getting straight into it today.
Yeah, exactly. Imagine initiating a retail client exit strategy. You press a single execute button to close an account, and you sort of assume the relationship is cleanly severed.
Right, that's the dream scenario.
But then months later, an auditor pulls the file, only to discover, a cascading failure of unresolved direct debits, mismatched general terms, and regulatory breaches that have basically exposed your institution to significant legal risk.
Which happens more often than you'd think.
Yeah. Today, we are unpacking a highly specific operational reality for institutions in Luxembourg. If you are managing a retail banking exit, or even, a partial portfolio migration, you really need to treat it as a strict payment services documentation and migration protocol. It is not merely a client communication exercise. We are going deep into the legal mechanics and the operational standards required for payment account termination, anchoring everything, of course, directly in the statutory texts.
That framing gets right to the heart of the risk, actually.
Yeah.
We need to strip away this conversational idea of simply closing an account.
Right.
Because from a legal standpoint, you are dealing with the termination of a payment services framework contract. When an institution decides to exit a retail banking relationship, it's exercising a contractual right.
A very specific one.
Exactly. And in Luxembourg, that right is heavily governed by precise statutory notice periods, fee restrictions, and an incredibly strict standard of traceability.
Let us start with the foundation of that contractual right then. The primary mechanism sits within the Luxembourg law of 10 November 2009, specifically Article 74.
Yes, Article 74 is the anchor here.
Right. So if I am an institution looking to terminate an indefinite framework contract, I cannot simply send a letter relying on, some vague overarching right to refuse service. Walk us through the mandatory statutory conditions.
Well, under Article 74, a provider-led termination requires two absolute conditions to be met. First, the right to terminate must be explicitly agreed upon in the framework contract itself.
So it has to be in writing from the start.
Exactly. If you pull a client-specific contract from, say, 10 years ago, and that contractual basis is absent or even ambiguously drafted, the right cannot be unilaterally exercised without severe legal friction.
Okay, and the second condition?
Second, assuming the clause exists, the provider must give a minimum of 2 months' notice to the payment service user.
2 full months.
Yes. Interestingly, though, the payment service user actually retains the upper hand regarding time. They can terminate the framework contract at any time, and any notice period imposed on the user by the institution cannot exceed 1 month.
Wait, I want to pause on a crucial operational point regarding costs here, because this is where institutions often run into compliance issues in practice. There's a specific 6-month rule regarding the fees associated with termination, isn't there?
There is, yes. The baseline under Article 74, Paragraph 2, is that termination must be entirely free of charge for the payment service user.
Right.
But institutions can charge a fee if the contract has been in force for less than 6 months.
How does the law restrict those early termination fees, though? Because they can't just make up a number.
No, it restricts them severely. The law mandates that any charge applied within that first 6-month window must be appropriate and strictly cost-based.
Strictly cost-based, so no penalties.
Exactly. You cannot use an early termination fee as a punitive measure or, a disguised revenue generator.
Yeah.
The institution must be able to demonstrably align the fee with the actual administrative costs incurred by unwinding the account so early in its life cycle.
So if you charge €50, for instance?
If you charge €50, you must be prepared to show why the technical closure cost €50 to execute. It's an evidentiary burden.
So connecting this back to the daily reality for anyone running an offboarding project, there is this common misconception that closing a retail account is just drafting a legally robust notification letter and cutting a check for the remaining balance.
Which is vastly oversimplifying it.
Right, but if we are legally unwinding a live framework contract, the operational reality is entirely different, isn't it?
It's completely different. A payment account is a deeply integrated operational matrix. It is not a static vault where you just take the money out and lock the door.
Right.
Therefore, The termination of the contract initiates a mandatory systemic unwinding process. The institution must actively facilitate account switching. They have to manage the complex handling of final positive balances, resolve any negative balances, and this is crucial, ensure there are documented routes for complaint management throughout that entire 2-month notice period.
That sounds like a heavy lift for the operations team.
It is. The process must be managed flawlessly until the final operational record registers a zero balance and a formally closed status.
That massive operational burden raises a key question about scope, though. Who exactly is protected by this regime? Because we are not just looking at one blanket rule for everyone here. There is a critical distinction between the law of 10, November 2009, and the later law of 13, June 2017.
The scope of application is fundamentally distinct between the two. The framework contract regime under the 2009 law applies to, quote, payment service users generally.
Meaning everyone.
It's a broad statutory category, yes. It encompasses corporate entities, small businesses, and individuals. A payment account under this 2009 regime is defined simply as an account held in the name of one or more users for the execution of payment transactions.
Okay, but what about the 2017 law?
The separate law of 13 June 2017 is strictly consumer-facing. It does not apply to your corporate users at all.
I see.
It introduces dedicated layers of protection specifically for consumers acting outside their trade, business, or profession.
To clarify the what in this scenario, we are talking specifically about the Payment Services Framework Contract. This is the durable agreement governing all recurring payment services, right? Wire transfers, debit facilities, direct debits, and standing orders.
Yes, exactly.
Because this contract governs live operational services in Luxembourg, situated within the broader European framework, unwinding it requires absolute sequential precision.
Yes, and that sequential precision is tied directly to statutory timelines. We discussed Article 74 requiring at least 2 months' notice for a provider-led termination. But Council must also factor in Article 73, which governs proposing changes to the framework contract.
Let me stop you there for a second. If an institution is trying to exit a client, why would Article 73, which is about changing terms, not terminating them, be relevant to an offboarding project?
Well, because an exit strategy often involves migrating clients to new products or fundamentally altering the service terms before an ultimate closure, especially in, say, partial portfolio migration.
Oh, I see. It's a stepping stone to the exit.
Exactly. Article 73 mandates that if a provider intends to change the terms, those changes must be proposed no later than 2 months before their intended date of application. So whether you are altering the relationship mechanics under Article 73 or terminating it entirely under Article 74, you are firmly anchored to a strict minimum timeline of 2 months.
From a business perspective, forcing the institution to maintain an active relationship for 2 full months and, jump through all these documentation hoops sounds incredibly frustrating, especially if they are actively trying to de-risk. What is the ultimate policy goal justifying this level of friction?
The policy objective is orderly client mobility and market stability. It ensures the client has sufficient time to transition direct debits for mortgages or utilities.
Right. You don't want a client's lights turned off because their bank dropped them overnight.
Precisely. A missed payment due to a sudden account closure can have disastrous cascade effects for a retail client. Concurrently, it ensures transparent pricing, the continuity of basic payment functionality, and a highly predictable handling of client rights.
How does that policy goal of orderly mobility translate into procedural protection for the institution, though? Because the execution sequence required is remarkably rigid.
It is rigid by design.
Right. You have to identify the exact account population, verify the termination clause in each specific contract iteration, and send the notice via an agreed durable channel.
It provides procedural protection through standardization. By adhering to a highly traceable execution sequence, the institution actively mitigates legal and regulatory risk.
Meaning, if you follow the steps, you're safe.
Exactly. If you map the account population accurately, verify the Article 74 right exists in the client's specific version of the general terms, and deliver the notice through a contractually agreed durable channel, like a secure banking portal or a registered letter, you build a robust defensive record.
And that record is what the regulators look for.
Absolutely. The CSSF and the legislative framework expect you to unequivocally prove the termination was lawful and properly communicated.
Let us put this into practice and open the playbook, so to speak. If you are sitting down to review a retail exit project, the legal review has to encompass 3 core documents. It is not just about drafting the perfect exit notice.
No, the notice is just the tip of the iceberg.
Right. You must review the general terms, the specific payment services framework contract, and the closure notice itself in unison.
That 3-document alignment is the absolute foundation of the operational playbook. The right to terminate must be established in the general terms and the framework contract. The notice is merely the execution mechanism.
So if the terms are outdated,
if your notice asserts a right that is ambiguously drafted in an outdated 2015 version of your general terms, for example, your entire closure process is instantly vulnerable to challenge.
let us say the contractual basis is solid, though. What exactly must the closure or migration notice contain to clear the compliance hurdle? Because I imagine missing a single detail here resets the clock.
It absolutely does. It requires forensic specificity. The notice must identify the affected accounts and the exact services being terminated. It must clearly state the intended closure date, respecting that 2-month minimum.
And what about the tied services?
Right. Furthermore, it has to detail the precise treatment of all tied services, what the client must do with physical cards, the timeline for halting active standing orders, and the deadline for rerouting pending direct debits.
And what about the financial settlement? Handling the remaining balance seems like the most sensitive touch point in all of this.
It is entirely critical. The notice must provide explicit instructions on the treatment of remaining positive balances, the exact protocol for resolving any negative balances prior to closure, and it must prominently display the available complaint routes.
So the client knows exactly where they stand.
Exactly. This ensures the client has a fully transparent view of the final settlement process and their right to recourse during that 2-month window.
Which introduces the ultimate operational standard here, traceability. In this context, traceability is not just a regulatory buzzword, is it? It is a strict evidentiary burden.
Absolutely. The institution must be able to pull a file and match the original contractual right, the exact wording of the issued notice, the technical evidence of delivery via the durable channel, the subsequent client instructions regarding their balance, and finally, the final zero balance account status.
That's a very long chain to keep intact.
And if any link in that chain is broken, if you cannot prove the notice was delivered, or if a standing order was left active, the closure cannot be fully reconstructed. That represents a structural documentation failure.
That brings up a practical friction point regarding costs, actually. We established earlier that under Article 74, Paragraph 2, terminating the framework contract must be free of charge.
Yes.
But what if unwinding a client's portfolio triggers incidental tax impacts? Say the closure requires specific capital gains tax reporting, or it generates administrative costs related to complex asset transfer documentation that sits outside the pure payment service framework. Is the institution forced to absorb those costs?
That requires a very precise distinction. The restriction on fees under Article 74 pertains strictly to the termination of the payment services framework contract.
Okay, just the payment account.
Right. The act of closing the payment account itself must be free. However, tax impacts and complex asset transfers are governed by different contractual and regulatory mechanisms.
So they can be charged separately.
If the offboarding process triggers separate obligations, such as withholding tax processing or securities transfer documentation, those are distinct from the payment service termination fee. The institution must clearly delineate between the free termination of the payment account and any legitimate, agreed-upon administrative costs related to the broader asset migration. You cannot bundle them together.
Looking at the broader context and the current market pulse in Luxembourg, market practice uniformly treats a retail exit project strictly as a controlled documentation and client migration exercise. The focus is purely on rigorous execution.
Yes, and for consumer accounts, you have to layer in the specific obligations of the 2017 law. This adds immediate practical obligations during the exit phase. So, institutions must ensure ongoing fee transparency, provide accurate annual fee statements up to the point of closure, actively support the account switching process, and importantly, ensure vulnerable consumers maintain access to a payment account with basic features.
Right, you can't just leave them stranded.
Exactly. You cannot simply close a consumer account if it leaves that individual entirely unbanked without offering the mandated switching support.
Checking the current regulatory radar, we can confirm there have been no structural regulatory shifts directly targeting retail account closures in the last 48 hours. The framework remains stable. In fact, if we look at the CSSF's latest publications around 19 May 2026, their focus was directed toward money market fund stress test scenarios.
That perfectly illustrates the regulatory environment. The CSSF provides a very clear, highly stable framework for retail operations.
It's a solid foundation.
It is. The recent publications regarding stress test scenarios demonstrate that while regulatory authorities are actively monitoring macroprudential stability and systemic risk in the funds sector, their expectations for retail banking exits remain firmly rooted in the established statutory texts. The mandate is simply the flawless, quiet execution of the existing law.
That macro focus from the CSSF underscores a key point. While authorities manage systemic risks elsewhere, the obligation for institutions managing retail exits is strict, quiet documentation discipline. Looking ahead, there are no upcoming account closure-specific deadlines under Luxembourg law identified in the official sources reviewed for this briefing.
That is correct. The statutory timeline is defined entirely by the specific execution date chosen by the institution, provided they respect the minimum 2 months notice under Article 74. There is no looming regulatory deadline forcing a structural change to these specific mechanics.
But we should note that adjacent regulatory developments are highly relevant if they impact broader structural elements. For instance, new requirements surrounding digital operational resilience, updates to outsourcing rules, or adjustments to client communication protocols. Those elements directly influence the operational machinery of an exit.
Precisely. To use operational resilience as an example, those requirements dictate how securely you must maintain and store the traceable closure file we discussed, especially if you use a third-party vendor to distribute the notices via a durable medium.
The storage and security become paramount.
Right. But the fundamental legal requirements of notice and fee restrictions under the 2009 and 2017 laws remain the absolute anchor. In the absence of new statutory deadlines targeting closures specifically, institutions must strictly align their compliance and operational protocols to these existing frameworks.
Let us bring all of this together into a practical mastery scenario. Imagine an institution is migrating a complex portfolio. The file includes joint accounts, dormant clients who haven't responded to correspondence in years, and vulnerable consumers. How does counsel actually manage this file from a legal and operational standpoint?
The blueprint is to run the file strictly as a legal migration. Counsel must first conduct a comprehensive mapping exercise. They categorize the clients. Are they corporate users governed solely by the 2009 law, or consumers protected by the 2017 law?
That dictates the rule book they use.
Yes. Next, they must review every applicable iteration of the general terms to verify that the Article 74 termination right is present and valid for each specific account.
And once that basis is secured...
Once the legal basis is secured, counsel aligns the closure notice, the account switching support documentation, the complaint handling wording, and the specific protocols for handling remaining balances. Finally, they must establish the technical mechanism to capture evidence of delivery for every single notice.
The hard work really sits in resolving the operational details, doesn't it? For a joint account, it means ensuring both parties receive appropriate notice via durable mediums. For dormant accounts, it is establishing how notice is legally delivered and evidenced when communication lines are cold.
It's always a challenge.
And then you have the systemic unpicking. Canceling physical cards, halting standing orders, managing pending direct debits, and ensuring negative balances are resolved prior to the closure date. And for vulnerable clients, confirming they have access to replacement or basic payment accounts before final termination.
The ultimate standard for success across all of that is reconstructibility.
Reconstructibility, I like that word.
The final deliverable of this entire process must be a comprehensive file where every single account closure can be forensically reconstructed. An auditor or regulatory reviewer should be able to trace the closure from the originating framework contract through the specific notice provided, across the client communication trail, right down to the final operational record showing a zero balance and a formally closed status. That is what traceability means in practice.
Before we wrap up, consider this provocative thought. As banking operations become increasingly automated, the manual paper trail of traceability we rely on today is highly likely to evolve. We are moving toward a landscape where these 2-month notice periods, standing order cancellations, and zero balance verifications might soon enforce themselves automatically through digital smart contracts, transforming compliance from a retrospective audit into an automated, real-time guarantee. Luxembourg is particularly relevant because retail banking, private banking, payment services, fund administration, and cross-border client relationships operate in a compact legal ecosystem where documentation discipline directly supports market confidence. Follow on Apple Podcasts, Spotify, or wherever you get your podcasts. Subscribe to Bertrand Mariaux and Rigore Media on YouTube. Connect with Bertrands on LinkedIn at bertrandmariaux.com, all links in the show notes. This was the Luxembourg Fundcast.